Thank you, folks. Go ahead and have a seat. Thank you. All right. And good afternoon. We're here for basically a status conference is what I'm going to call it in 1CA JV 24061 in re DCS/Guardian. As you may know, we record and live stream this proceeding, so please give your name and the name of your client when you begin. And what we're going to do today is have a conversation. The Attorney General's office asked for this status conference today to ask questions. We also have some questions, as you might imagine. And so we don't have a time limit set, but we have gone through the materials that have been provided in the history, starting with this about a year ago. So let me take just a moment to kind of set the stage for this and review the history behind the administrative order. Last year at about this time, the Attorney General sent a letter advising the courts of a major disclosure problem that was created by the Department of Child Safety's use of the Guardian system. The Attorney General's office also assured us at that point that it would probably be all cleaned up by the end of September of last year. We're still here. It hasn't been. So what we're looking at is how is it that we're going to see these issues get resolved. We'd love to see it by the end of September this year. And what I do want to do is I understand that the department and the Attorney General have worked on the issue. I appreciate the effort. My understanding is you have made some progress, but from my perspective, not enough. And that's why we're here today. We continue to have stay cases because of disclosures that did not happen now, a year into this process. We have notices that DCS in the department sent information to a parent and told the parent they could request a stay without counsel, without the benefit of that, and somehow, I suppose, believing a parent would know what it meant to even request a stay. We have reports that we've received from the department that have incorrect and also inconsistent information about cases. We have at least 2 adoptions that occurred after we issued a mandate without the department advising us of the Guardian issue and requesting a stay. So from our perspective, something more needs to happen. We have a hearing set in October, which we reaffirm here today. Today's hearing is to answer questions the department has and anything about the order and what you're required to do. As a panel, we have some questions that we'll have about how you move forward. You can expect that after today's hearing, we will issue some further orders that relate to the 8 counties over which we have administrative responsibility as far as receiving their appeals. I do not serve as the administrator for that court or supervisor for those courts, but we do receive all of their appeals. So it matters to us what is happening in those 8 counties. We need a process to ensure that we stay cases if there is a Guardian issue that exists, which means we need to know a process to have that. And unfortunately, the process we put in place doesn't seem to have worked as well, and so we need something more. In that regard, Counsel, if you have thoughts as we're going through this of what we need to put in place, we'd be happy to hear that from you and from your client. Please speak up. Now, Mr. Lujan, we ordered you to be here today. We're not expecting to swear you in here today. Come October, that may be a different story. But if you want to add something after we hear from your counsel and ask questions, we'd be happy to hear from you. Anything that you would want to share. In part, we wanted you here so that you knew how important this is to us, and that we're standing at this point, on the edge of what is the next thing that we have to do. And we would prefer not to have to do that or go further, but we will if we have to. So with that, Counsel, I've covered everything that I have in those notes. So why don't I go ahead and hear from you?
Good afternoon. May it please the court. I'm Kirsten Wright, Assistant Attorney General, appearing on behalf of the Department of Child Safety. As Judge Goss stated, my client, CEO David Lujan, is here in the courtroom with us, as is General Counsel for the Department, Catherine Patak. She's in the gallery. We received the court's order of July 26th, and we asked for the status conference so that we may provide the court with all of the information that they're seeking. We want to ensure that we're providing the court with our best possible information. So if the court will permit, I'd like to ask a couple of questions of the court so that we are able to do that. First of all, in both the March 28th administrative order and the July 26th order, the court mentions two cases, CA-JV 230023 and CA-JV 230098. We did file a substantive pleading regarding those two cases on April 29th, and I wanted to inquire whether or not the court had any additional concerns regarding those two specific cases. As far as the department and the Attorney General's office is concerned, those two adoptions proceeded legally appropriately. And so I know the court was concerned that they did not receive information, and so I just wanted to inquire as to whether or not you had any additional questions on those two particular cases.
Well, we had a case that, and we don't want to go into specific cases, so a group of cases that in which there was a guardian disclosure issue, in which this court had gone through its process, had issued a decision, and we never heard anything about what those disclosure issues were. We never heard anything about a request for a stay. We weren't given that update, and then they proceeded to mandate, and then the adoptions occurred. So I understand from the department's perspective, but we had orders in place that said when this thing happens, we stay, it goes back to the Superior Court. The Superior Court's in the process then of working with you, and we'll talk about what we need to do for that, but to have counsel appointed for people whose rights were terminated without full disclosure of the documents that they had a right to. Now, whether that might ultimately change the outcome of the case, we don't know. But they had a right to those beforehand. And so that is the concern. That, are there other cases that you're allowing to go through to mandate and to adoption without advising us fully of those, and why?
So I can only apologize for us not advising you on those two particular cases. However, the documents in those two cases that the court had requested information on had been previously disclosed, so those parents did have those documents prior to either of their terminations proceeding to trial, which was why the adoption was able to proceed, because they were documents that were in the portal, but they had been disclosed in another manner.
And did you tell us about that?
I don't have that specific information. I don't know if our appeals division provided this court with that information, and I can certainly check on that.
Or have they been instructed to do so?
They have been instructed to do so, and with regard to the cases that we filed the stay in, we put a protocol in place so that our appeals attorneys would follow that protocol. It appears to me as these two cases were at the very beginning of this process, and they occurred at the beginning of the process where we might not have had it nailed down quite completely. This has been an ever-evolving situation.
And what is your protocol for letting us know?
So in the cases where we have a case that is currently on appeal and we identify that there are documents that were not disclosed prior to the termination, we're requesting the stay. We went through a significant amount of process changes due to the fact that the defense bar was very resistant to being reappointed. The first few weeks when this occurred last August, we were sending documents directly to the last appointed, most recently appointed counsel. And initially they were accepting the documents. We were assuming that they were speaking to their clients, because that, how they handled that once the documents were sent to them was up to the attorneys. And we didn't have very much resistance. We thought we would move through things very quickly. At a certain point in time, the defense bar decided that they were not going to accept the documents, and they had asked for motions to reappoint counsel to be provided. We started filing motions to reappoint counsel in all of those cases. And then the defense bar decided that they did not want to be reappointed anymore, and that because the cases were closed, that there was no jurisdiction for us to even be asking for them to be reappointed. In addition to the response from the defense bar, we also had we ran the gamut of judicial opinions. Some judges were reappointing counsel and telling them, if I reappoint you, you're going to take these documents and reach out to your former clients. In other cases, we had judges who said the case is closed, we're not going to be moving forward. We had judges who would ask for us to disclose the documents directly to them, and those judges were reviewing the documents and making assessment whether or not the documents would have had an impact on the termination. So each individual attorney and judicial officer handled the situation differently, and we were trying to play catch up during that whole time, trying to figure out which party wanted it done which way, and there was no consistent manner with which to do that. So at a certain point in time on the cases that were on appeal, the decision was made that it is most likely the only way that we could assure the parents get the documents was to send those documents directly to the parents, and the department is working on that process right now.
How would any ordinary parent know whether those documents were significant? And if you told them you can ask for a stay, if I were not legally educated, my question would be, what's a stay?
I absolutely agree with what you're stating, Your Honor, which was why our initial determination was to send the documents to previously appointed counsel, because it was the department's position that the parents should have the right to have counsel explain what was happening to them. Unfortunately, the department can't appoint counsel. The court has to appoint counsel, or counsel has to agree to be reappointed, and we did not find that that was happening in these cases.
Well,
So
if you had a case where a trial judge said, I'm not reappointing counsel, and I think you would think that counsel should have been appointed, did you consider doing a special action to this court, saying that the court abused its discretion in not reappointing counsel?
I do not believe that we considered a special action at that point in time. And perhaps that's something that should have been considered. We did have some orders specifically from Judge Goss stating that counsel on specific cases needed to be reappointed. And in those cases, the Superior Court judicial officer did reappoint attorneys. So we were hoping that that would be the position of all the judicial officers, and it just didn't appear as that became a consistent method for getting counsel to the parents.
Well, why didn't you take some action to get the consistency? Because from my perspective, and your past is representing these very parents.
Absolutely.
These very parents whose children and their rights to them may have been terminated inappropriately. Why didn't you try and get some consistency?
I cannot begin to tell you the frustration that we felt. And Your Honor does know my past. I did represent parents and children who are involved in these matters. As an attorney representing a parent, I would have handled it differently than a lot of the attorneys chose to do. Things progressed very quickly and yet slowly at the same time, and so we were trying to address the situation as it came about. The only way that we felt that we could ensure that parents received the documents was if the department were to start sending those documents directly to parents with a cover letter that provided them the information of their prior counsel. So it has their counsel's information and the information for the court in which their matter was heard, so that they could call the court and request reappointment of counsel.
But you were ethically prohibited from giving them legal advice. So if they weren't legally trained, what good is having your nice letter?
I think that's why, because we are ethically prohibited from providing legal advice to the parents, that is why we provided them with the name of their prior attorney, and that if you have questions, these are the people that you should reach out to.
And so there was the sort of the first batch of cases where you learned that there had been a failure in disclosure due to the guardian system, but then there was another group of documents that were not disclosed, right? So
Correct.
A second wave. Would it help you, should there be a blanket order, administrative order from our Supreme Court telling the trial courts that when there's a case of this nature where there's a disclosure issue, counsel should be reappointed?
I don't think it's appropriate for me to opine whether or not an order should be made against Parents Council. If that were to occur, I do think that it would.
Well, it wouldn't be an order against Parents Council. It would be an order to the trial court that when a case has concluded and it is discovered that there's a disclosure issue, that the trial court should appoint counsel. That's my question. Should the Supreme Court issue an administrative order to our trial courts so that this is not a question?
At this point, I do not think that the department would object to an order such as that. And for this court's information, there was conversation regarding ways to try to make this a standardized order. It was recommended that we have buy-in from the defense bar in order for the Supreme Court, to feel confident in issuing a blanket order, issuing that. And we were not able to get buy-in from the defense bar. In order to be able to propose something to the Supreme Court, this is how, the parties all agree that this matter should be handled. We're asking that an administrative order go into place. We had a significant amount of pushback from that.
And really, the elephant in the room is money, right? Who's going to pay for these services?
I would imagine that was a significant portion of the pushback that we received.
Right, because I can't see how attorneys who typically represent parents would not want to look at additional documents and provide additional assistance unless they were being asked to do so for no pay. Is that what's happening?
I can't opine
the
as to
extent
what's
that you
happening.
know?
We started receiving pleadings from the defense bar arguing that because the case was closed, that there was no open case in order for them to be reappointed in, that they were time barred. There was a variety of pleadings that we received arguing various arguments from defense counsel. Never once in those did they mention cost. I am surmising that it would be a pretty significant cost to the various counties to reappoint counsel.
Should that cost be assigned to DCS? Or should other agencies have to bear the expense of reappointment of counsel because DCS, because the Attorney General's office failed to make full disclosure? Who should pay for it?
I'm not certain as to who should pay for that because I don't know what the actual cost would be, if it would be cost prohibitive to any specific agency. I will say this, that in the majority of these cases, the documents would not have had an impact on the case. They're one or two documents. Many of them don't contain a lot of substantive information, but they're documents that absolutely should have been provided to parents prior to their termination hearings or however their case ended.
But that decision isn't yours to make.
Exactly. I agree with that, which is why we chose not to make that decision. The Attorney General's office, in conjunction with the department, could have very easily looked at each document and said, that won't matter, and put it in the trash. Oh, this one won't matter. But that wouldn't be just. That would not be fair to those parents. They should have had the opportunity to review those documents with their counsel and have their counsel advise them as to whether or not it was important. The reason I mentioned that in looking at a lot of these documents, we're not certain that they would make much of a difference is I don't think we're looking at a significant number of cases where counsel would be reappointed and the case would have to be reopened, an adoption overturned, a retrial of the termination hearing. I think that would be a very, very, very small number of cases.
Counsel, we're talking about a parent's fundamental right.
I agree with you.
I think one is probably too many, and there are more than one.
I agree with you. I don't know that there are more than one, but I couldn't agree with you more, Your Honor. My point is that from a cost standpoint, I don't think these cases would be open for a significant time. I don't know that there would be a huge cost to those agencies to look at these documents and assess whether or not they needed to take a secondary
Isn't
look
part
at
of the
it.
problem that just reappointing counsel isn't enough because it's still got to re-engage the parents? Has DCS served these parents and brought them back into the litigation, triggering the obligation to appoint counsel? Because that seems to me the way to do it.
So the department is working on that system now. In some cases, some of the appeals cases, we have asked the department to send those directly as the case is coming forward to make sure that the parents have those documents prior to the appeal coming before Your Honors.
I'm sorry, would that the parents have it?
Yes, and if they have appointed counsel, if they have appellate counsel, we're sending it to them. Some cases are post-termination and they haven't appealed yet, and it hasn't started, so we're asking that the department send documents
So I'm
to
aware of
parents.
several cases in which something along those lines has happened. Why is the department not giving us notice of those so that we can look at it? Because we're finding them where suddenly there's a notice that the documents were sent to the parent and there's an appeal pending, but there was no notice to us, and we're sort of in the dark on what's really happening with that.
So that's communication that we can absolutely start having with this court. So
So they're relatively recent,
yes.
which means the disclosure is still lagging. Because why would we have a brand-new appeal in which the case is going at issue and the council are still getting notice of late disclosure for guardians? So I guess my question is, and we wanted to give you a time to ask questions, so I'm going to come back to this because I have it on
Okay.
my list, but think about this.
Why
Why are we current with all the cases in the 8 counties that we're responsible for?
current with disclosure?
Yeah.
No, we are not.
How far behind are we?
Probably in the 7 counties that do not include Maricopa, I would say that disclosure is pretty close to being current. I'm not certain it's within that 10-day time frame, but I would say it would be within a 30-day time frame. In the smaller counties, they have significantly less disclosure than Maricopa County. At this point in time, and if I may turn around and just get
Sure.
confirmation, are we looking for? I'll explain the next. Okay. So currently, they're approximately 4 to 5 months behind in their disclosure. The department is attempting to contract with a disclosure agency to be able to process that backlog of cases so that the centralized records unit can get on top of things and be able to move forward, starting
Why
kind
has
of
that
at
not
zero.
happened up before now? And that's, I guess,
I
part of
don't-
why
I
we're
don't
here
have
is
the-
last September, this was supposed to be fixed. Why are we only looking at it now?
I don't have the answers to that. Some of that is possibly financial, just resources based. I think we thought this would be easier to process through. If the court will provide me leave, I would love to explain to the court how we've had to go through the analysis of these documents. With regard to the post-mandate cases that the court asked us to look into, the Attorney General's office had to compile a list of all of those post-mandate cases and provide it to the department. Unfortunately, the department does not track their cases by JD number or court number. They track their cases by person. So in order to have the department look to find all of the documents that could pertain to a case, the Attorney General's office also had to provide the department with the case number that we're looking at and every single party that was involved in that case. We sent that list over to the department. Guardian also has no way of automating this type of information, so every single document had to be hand-pulled by a human being looking at this list, going into the portal and pulling those documents out. The department had a team of 25 DCS staff who were enlisted to review each of those names and pull the documents assigned to them, and that each staff person spent between 10 and 20 hours per week for 3 weeks to check the post-mandate cases against both the 96 original portal documents and that secondary backlog of a little over 100,000 documents, many of which were already disclosed, but the department couldn't verify that they had been disclosed, so they went back through that second 100,000. The department then took those documents, noted it on a spreadsheet, and pulled the documents out and put them into a shared drive that the Attorney General's office could then look at. So the department spent approximately 1,000 staff hours pulling the documents just for these post-mandate cases. And that doesn't include hours for quality assurance, project management, the IT help that was needed, the training that was needed, the creation of the SharePoint, and the management of the SharePoint. Many of the staff that were using Guardian had never gone into that kind of a deep dive into the Guardian system, so they had to be trained, which took some time. The department did have a daily call with all of the staff reviewing this documentation and making sure everybody was on track. They created a workflow that everyone followed so that it was done consistently. And once they completed that and the documents were uploaded to the SharePoint, then the Attorney General's office started our review of the documents. When looking at the disclosures, we had to determine whether or not they'd been disclosed before, which would be a search on JAX, looking at the list of witnesses and exhibits that had been provided, looking at exhibit lists from the trials, looking at our subpoenas to see if we had disclosed these documents before. Sometimes this analysis gets complicated by the fact that children take different pathways. So you may have a child who's the subject of the termination, but there may be other children who still are engaged in the dependency. And so what we were finding is determining the date of that document and which child it pertained to was a pretty tedious task in order to be able to document for the court to know that we were giving you the right child in the right case, and not leaving out other children that may or may not have been a participant in the specific appeal. I would note that this court had also asked for us to determine if a notice of disclosure had been filed in the Superior Court. A lot of this disclosure had gone out through JAX or through email, so that we would not have filed a notice of disclosure with the court because it would have been just part of our regular disclosure process where the disclosure goes out every so often and gets uploaded or emailed in another way. So in some of the cases in the document that we provided this court, it might say that disclosure was made, but no notice was filed, and it would be because we didn't need to file a notice. The disclosure had been sent out in another manner rather than a notice to the court. So once that analysis was complete, we entered as much information into that Excel spreadsheet as possible. We believed that the spreadsheet was going to be the easiest way for the court to be able to see the information. We toyed with the idea of doing a one-page report for every single case, but we thought the information would get very confusing in a single page for each case. So our position was that the Excel spreadsheet provided this court with the most accurate information for all of the different areas that we looked at. Our office had 15 to 20 people working on this with an estimate of over 500 man hours. So we are somewhere around 1,500 man hours to provide this one report to the court. And it was a pretty significant undertaking. Both the department and the Attorney General's office are continuing with their regular duties in addition to providing this. I would like the court to know that this was a human-centered process. Nothing was automated. Everything was done by hand. And because of that, there's going to be some human error. There are going to be some mistakes that people made that we believe we reviewed and that we might have caught, but obviously with some of the concerns that were raised in the order, we may have missed some of those. We have gone back through those 37 cases that were identified in the July order. We found 2 errors with regard to names where the case was correct, the documentation was correct, everything else was correct, but someone must have put the wrong name in. And when we're looking through the document for inconsistencies, we didn't notice that. So we've corrected those 2. And then with regard to identifying the documents, our direction was to utilize the title at the top of the piece of paper, hoping that that would give us some consistency with regard to how people named the documents. But what we have found in reviewing the cases that were pointed out, some people must have made acronyms, which they probably should not have done that. So for example, supervised visit only report, some of the reviewers were putting SVO for supervised visit only. So we've corrected that. We've elongated any of the places where there would have been that acronym. And then we've also added which parents the documents were disclosed to on the cases if we had that information.
So are you convinced that you've gotten you're aware of all the cases where there has been a disclosure issue? I was looking at the response to our administrative order, and on page 3 you go through the color coding procedure that you did on the cases, and you identify 108 cases where you say that there either has been disclosure or there hasn't been disclosure, which takes in the entire universe. There's no distinction. So, I mean, what does that mean?
So it could be a situation where there's a multitude of ways that that could work, and perhaps we need to add additional information. So we were only looking at the portal documents. So the disclosure would have been of the portal documents. So a situation might say, yes, there were portal documents, and no, they were not disclosed, but they might not have been disclosed in this particular appeal because they were documents that pertain to another child that's on a different track. So were they disclosed to these parties? They might not have been, they weren't disclosed to these parties because it wouldn't have applied to these particular parties. So if that's the kind of further information that this court would like for us to include, we can absolutely include that.
But that, and the answer in the response is not useful to distinguish cases, correct?
So probably the answer then in the response might not be useful to distinguish cases, but we believed that the appendix distinguished the cases.
Okay.
And that the most information was provided in the appendix, not in the body of the response.
So counsel, I mean, is it because there were a number of cases and we listed some of them where it was completely inconsistent, which said disclosure is complete, but also listing undisclosed documents. So that's, I mean, there's just an inconsistency that I can't resolve when it says something like that.
So we considered any document in the portal to be an undisclosed document. And when we looked at that first assessment, and this court said in the order, the first order of March, identify the undisclosed documents. We interpreted undisclosed documents to be any document that was in the portal. And what we're finding is some of those documents were definitely disclosed through subpoena or, as part of the trial, because we would have requested them from the Attorney General's office in a different manner than they were provided to the department. So that's why we list out what the documents were and when they were disclosed, so that this court understands how many documents we're talking about that were reviewed. We considered any portal document to be undisclosed at the time we reviewed these for the court.
I think you probably need to add some further clarification on that because it reads as inconsistent and we weren't able to resolve it in going through our review.
Okay. Other than the areas that we identified where we found some inconsistencies, were there any other issues that this court would like for us to resolve for them?
We will, but why don't we go through your questions first?
So our question, we looked at what we thought looked inconsistent. Unfortunately, when you've looked at a document like this for so long, I think we know what it is we've put in there, and we're not necessarily aware of, we want to make this as easy for you all as possible, and it's an immense amount of information that we've tried to provide. So I understand why some of it might have been confusing. So I think our real question is just a blanket question, despite the couple of issues we found ourselves, or is there anything additional that this court would like for us to clarify?
Well, we're looking at counsel now. I'm going to speak for me, not everybody else. Is we have cases that we're still having to stay. We have cases that we're not even sure if we should stay because of how it's coming to us, because no one's telling us. We're just finding a disclosure post-adjudication with really just floating out there. Okay. And we don't know even if the parents have gotten it. And our concern is issuing a mandate. I have two cases that we'll probably have to stay at this point to figure this out. And issuing a mandate and having an adoption go forward in a case that should never have moved beyond the Superior Court. It should have gone back there. So what do we do to make sure none of that happens going forward?
I would request time to be able to come up with what that solution would look like from our end, and perhaps discuss that at the next status conference. It's requesting from you what types of orders that we think would be appropriate isn't something that we were prepared to come forward with today. So we certainly can improve our communication with the court.
What have you thought about as far as a way to do this? You've got to have had some thought on how to make sure we don't have cases here that are still in the middle of disclosure. So
what we have done is severalfold. cases that are coming up to trial, since we found out about this in August, we have asked the department to look into the portal and find us those documents that are related to any case that was coming forward. And we did that with regard to adoptions as well. So at the very beginning, we were looking at every single week what adoptions are coming within the next week or 2 weeks out, seeing if there were any portal documents. We were working with the adoptions bar because, I mean, they certainly didn't have a mechanism for getting back in front of the court because they represent the adoptive parents. They wouldn't have been a party to the underlying dependency or termination case. So we were working with the adoptions bar and getting those, please tell us when all of your hearings are coming up. We're working on those. If there were matters, that's when we were filing the motions to reappoint counsel. I mean, if there were documents, that's when we were filing the motions to reappoint counsel and to try to get anything that could be resolved in the Superior Court resolved prior to a case going to adoption. And then we hit the wall with regard to being able to have people that were willing to accept the documents or have the courts assign counsel. And so that's when that kind of stopped. We continued to work with the adoptions cases and trying to make sure that we could notify them that there was an underlying document. So we did that part. We have continued to work with the court. I know that Judge Bustamante has sent lists to the department of the upcoming monthly, a month block of trials, and the department is ensuring that all of those documents are getting out for those trials so that we're not slowing down the trial process. So there are methods in place so that hopefully we'll get to a point where everything has been disclosed and cases have worked its way through. We may have some cases that had documents in that second 100,000 that are now, that's why you're seeing them, is because we're considering those portal documents that may or may not have been disclosed, and we're looking at those to make sure that they have gone out in a timely manner. So you may just be seeing those cases, as cases don't resolve quickly in juvenile court. So you may be seeing cases that had documents from August to December, and they're just now coming to termination. Hopefully those documents have already been disclosed, but we would consider them a case that had portal documents.
So counsel, if we were to require that somebody from your office, and consider who, can provide an avowal that a case, upon the filing of a notice of appeal, that the case does not involve any delayed guardian disclosure issues, is that something we can do?
That is not something that our office would feel comfortable with because
Why
we
not?
aren't the keeper of the documents. We don't have the ability to go into Guardian and look and make that avowal ourselves.
So if
So
we
the
ask
department, has the documents. So that was something initially for the adoptions that the department was willing to have someone avow that they had looked into the portal and yes or no, there are portal documents. If there are no portal documents, they were sending affidavits in. So that was being done at the outset. But like I said, we then gotten to a point where we were unable to move forward in the Superior Court with a lot of our disclosure.
So if we ask the department to provide an affidavit, who would it be? Because it doesn't seem like the caseworker is the right person.
That would be something that I would like to discuss with my client, and I can get back to you, and we can certainly answer that question in our next filing with this court.
So and lawyers have duties of disclosure, and why can't your counsel say, nope, I've looked at this as best I can, and from my perspective, it's not, there's no post-adjudication disclosure issue?
Because we don't have access to all of the documents. We don't have access to Guardian ourselves. The access to the documents that we have are when the department uploads them into SharePoint. So I just think it would be, I would hate to put an attorney in a position to make that avowal. And, the department runs by people. So, if someone isn't doing the exact correct pull of the documents by person, there may be a document related to another party in the case that our attorney would not know exists, or the department would be able to see that, but the Attorney General's office would not be able to see that. So I just don't think that it's the right person to make the avowal.
Then who would it be?
I would like to discuss that with my client if possible and get back to you just to see if the department has somebody that would be able to do that.
So here's the concern. If the department or the Attorney General isn't able to provide the affidavit or make the avowal, why would we not stay that case and send it back to the Superior Court? Because we're, at that point, dancing with an unknown and potentially moving forward to terminate rights in finality and allow an adoption to occur.
I completely understand Your Honor's concern with regard to that.
So we'll figure out who, but we will be able to get an affidavit from the department that there are no disclosure issues on every notice of appeal?
Again, I would like to discuss that with my client before I give you an absolute answer on that, but we will give you an answer in our response that's due on
I'd like
September
that
24th.
a little sooner than that, because
Okay.
we're looking at some orders before that October hearing at this point.
Okay.
What is the status of solving the disclosure issue going forward with Guardian? Have you changed, procedures
So,
to see that this doesn't happen going forward? I'm just talking going forward.
So, Guardian has some pretty significant limitations. It was designed for social workers. It was designed for them to input information into the system. It was not designed for the legal process to be able to pull that information back out. So Guardian is successful from a social work standpoint in their ability to maintain their records, but it has not been as successful in its ability to release that information for the legal purposes of the dependency. So
with that limitation, how have you at least proposed to fix that?
So the department, I believe the original group that developed Guardian was Microsoft. The department did not find that they were receiving what they needed. They are now working with IBM. I think they're also in consultation with the other agencies. So they're working from an IT standpoint in a way to streamline this and make it able for people to be able to pull the information out much easier, perhaps having them case related rather than person related. So that is in process, but that is a slow moving effort. In the meantime, the department has hired several people in their centralized records unit. They are trying to get more people on staff. I think, as you know, the state has a hiring freeze. The governor's office has graciously said, we want this to get fixed, and we are going to make sure that you have the staff that you need. So they're hiring additional people to work through those records. Additionally,
Counsel, that hiring freeze just came in recently. This has been going on for a year. I come back to my but not enough.
At this point in time, there have been some changes that have been made, and the department is working with an agency to outsource. I believe there are 2,700 documents left, or actually as of today, there are 2,500 documents left of the 100,000 that still haven't been disclosed. Those are
Is this the second 100,000?
the second 100,000. So
And
that's
how have they been disclosed? How? That's the other, by emails to parents in a vacuum?
So a lot of those cases were still open cases, so they have been uploaded into JAX and provided to the attorneys that are on those cases. They're also seeking to see if they can contract with an outside agency to get letters sent out to parents on all of the documentation. Any case
That was brought up several months ago. Why has it not moved further?
I don't have the answer to that, but we can certainly get that from my client.
So that seems to be the ongoing problem is we're not sure why not, but it hasn't happened yet. And so I think we need in October to be able to answer the why it hasn't happened yet.
And you've agreed that disclosing it to the parents isn't very helpful.
I would say that I've agreed that the parents are certainly entitled to those documents, and that is the one way that we can ensure that they are receiving them. I would agree with your assessment that without counsel, it's hard for a parent to analyze the document and know what it means. And so in the letter that the department's providing, it's letting them know to reach out to their prior counsel and provide the court information so that they can contact the court and request the counsel be reappointed. We have spent many, many hours trying to come up with a perfect solution, and unfortunately, I don't think there is a perfect solution in this situation. I think trying to get the documents to the parents to the best of the department's ability is what we've been trying to accomplish throughout the entirety of this.
Has the department tried to reserve them to get them reengaged rather than just sending an email or a letter?
No,
Why not?
I don't have the answer to that question, but I can get that for you.
with regard to the 8 counties, what we're looking at and thinking about is a status report as to what action has been being taken in each county, so that we know. And we're talking about the closed cases, but also the open ones. As you've indicated, there's 4 to 5 months lag. And again, we're still seeing cases that are actively just being appealed that are having post-adjudication disclosure. So what process is being used in each of those counties?
Okay.
What's the time schedule to get caught up here? 4 to 5 months behind.
So we are hoping that with this outside agency that we would be able to be caught up by the end of September. That is the goal. I cannot promise that. That is not within my control.
And that by the end of September, you will be able to say, look, in all the current cases going through the process, we don't have backlog. They're getting moved through.
That is certainly our hope.
And I'm understanding from you that's going to take a bit of a Herculean effort. How are we going to make sure that it happens every day going forward? Because this is, my concern is I'm here again next year, and I've got 3 more cases that have had this happen.
So in the outer lying counties of the 8 that you are over, Maricopa County is the one that uses the centralized records unit. The volume that comes in through Maricopa County is immense. The other 7 counties, their case managers, or they'll have a case aide, is responsible for that disclosure, and we are finding that they are not far behind at all for the most part. So it is Maricopa County that has the lion's share of the disclosure, and the department has hired up their CRCU people. I believe that they're hiring an additional 9 people to look at that. So at a certain point in time, getting rid of that backlog, should be on track, and will be able to maintain disclosure as it should be. I will say that because of the nature of a dependency case, we don't have a finite set of information. You know, in a criminal matter, you have an incident, it happens, this is the only amount of disclosure that you're going to get on that case. In a dependency case, the information is forthcoming, and it continues to the day of the termination. So any efforts the parents have made in those couple of weeks prior to a termination trial, the department may not have received those records yet from the provider. So mom and dad's last few visits, we might not have those records because they haven't been generated by the provider. So there's always going to be a few documents that may not have been entered into evidence that could have been relevant to the case because the documents haven't been created yet, and they get created after the termination. So it's a situation.
The problem is, counsel, I'll just jump in.
Sure.
We're also talking about documents that were sitting with the department and were not given to the parents' counsel and may have helped their case. I sat on the juvenile bench, as you may recall.
I do recall.
And I sat there for plenty of times and listened to the department saying, we haven't gotten those records. I would probably question that very differently today than I would have then because of the guardian issue. Because my question would be, is it sitting in guardian? And so how are we making sure that we don't have the very documents you're talking about? It's not that they don't have it, but that it's just sitting in guardian and it hasn't been pushed through for this year, for this case.
So I will say one change that the department made from an IT perspective is provider documents used to come into the portal, which is why we called it the portal, and then it was the case manager's responsibility to go in every week, look for documents that pertain to their cases and pull them out and stick them in, their side of the system. That has changed, and the documents no longer sit in the portal. The documents are moved. Sorry, I keep hitting that. The documents are moved through into the cases. So the case managers have those documents now in front of them. When they open their case, they can see what's there. They're putting packets together and sending those to CRCU for redaction, and then CRCU is disclosing those documents.
So what you will be looking for, and there were several questions you'll be working on, but one of them is identifying whether it's the case manager or the other person you just mentioned who sends.
CRCU is the centralized records unit.
Right. Which one of those people is the one who should be responsible for ensuring that all documents that should be disclosed are correct?
Yes. And
I guess
because
my concern is with that automation, how are we 4 to 5 months behind?
due to the redaction, so almost every document that comes through will be a mental health record. It could be a regular health record, drug treatment records, drug testing records. Those are all things that have to be redacted. Social security numbers have to be removed. Any document that comes through with regard to placements information has to be removed. So there's a redaction process that goes through, and I asked earlier today, and I'm not sure I have the number written down in front of me, but when we were requesting or the information from the department this morning is what is the actual number of the second 100,000 cases that have to be disclosed, and we were told it was about 2,500. It's over 120,000 pages. Those 2,500 documents are 120,000 pages. Every single one of those pages needs to be looked at to make sure that there isn't information that needs to be redacted.
But that's not new.
That's not new, but I think the volume is significant, and so I do think that that's part. I think that there is an increase in volume of documentation.
In terms of, you've mentioned how you're going about making sure that the disclosure happens before the adjudication hearing. Can you tell us what that is? So that we avoid the issue that we are running into, which is the post-adjudication disclosure.
So in Maricopa County, the presiding juvenile judge is sending a list of cases that are set for trial at the beginning of the month for the next month. The department is looking at those cases, and they are pulling all relevant documents. And again, this has sort of slowed down regular disclosure because they're focusing on the cases that are set for trial and ensuring that all of those documents have gone through, which is putting regular disclosure on a case that may be post-dependency to the back of the queue, because they're trying to make sure that they're getting all this information out so that we aren't delaying trials, and we're making sure that that disclosure has gone out. Should a case go up on appeal, everything was disclosed prior to trial. So the focus has been on ensuring, as a trial is coming along, that the documentation that the department has is going out.
I'll use a common expression, so robbing Peter to pay Paul, because all of those parents in those dependencies are sitting there and perhaps doing quite well, but the documents aren't getting disclosed.
So our office is looking at any time there is a case plan change request from the department. We staff those cases with our client prior to agreeing that there is sufficient evidence to move forward on a severance. Our attorneys are asking the case managers, you need to make sure that we have everything before we'll staff a case. So we are trying to look at things from all aspects, and so that might relate to children staying in care longer, but we are trying to slow things down to ensure that everyone has the accurate information. So case plan staffings, we're asking the case manager, please get us that documentation before we assess whether or not we should change the case plan.
So our goal, and I think we've made it clear, is to make sure when a case gets to us, there's no post-adjudication disclosure issue. And we don't have that, and that if there is one, that we get adequate notice from the Attorney General based on your client's information. Any question on that goal?
No question on that goal.
So is there anything from your perspective we need to do to make sure we meet that goal? Besides some of the orders we've talked about, but what can we do to try and make this work? Because again, we're a year in, we're 4 to 5 months behind. Parents in regular dependencies now, from the sounds of it, are suffering because the disclosure isn't happening timely in those cases. So it's not getting better. So what do we do to get it better?
The only thing that I can say to you now without discussing, we have a great group of attorneys at the Attorney General's office who have staffed this together. We talk about it. We try to come up with game plan together, and we then have a conversation with our client to see if it's something that the department can do. We have not had that conversation as to what we can ask the Court of Appeals to do to assist us. So I would like to go back and have that conversation with the other attorneys in the office and the department so that we're providing you with an adequate request that could help solve the situation.
And bearing in mind the fact that we are in sort of a unique position because We're not the trial court, but we also are not the Supreme Court, and we don't have administrative power over the trial courts. So keep that in mind.
Okay.
And what may be better to be addressed by the Supreme Court in terms of perhaps an administrative order.
Right. And then just, is there anything specific we can add to our appendix to help make this easier for the court?
I think clearing up that issue of when there are 188 cases, it's a disclosure was made or not made, and I don't even know what to do with that. And so
Okay.
I think that question needs to be answered.
Okay.
I think we're going to be looking to you to know exactly what the status is in each of the 8 counties and why. And we will be looking at that. You can expect that we'll probably be looking at an affidavit and possibly an eval in candor, because the attorney has done their due diligence, at least in making sure that that's the case. Because right now, again, we're a year in and we don't feel a lot further down the line. I know you've moved a lot, but we just haven't gotten enough done. And there are still people whose rights are being affected by this. And again, I know you've represented them, so you're well aware of that.
And it seems it would be helpful to this court if one could confer with the client to identify the person either in DCS or the AG's office who is responsible to make the determination whether the disclosure has happened or not.
Okay. We will discuss that for sure.
So if we could have that information filed by the end of next week
End of next week?
as to who and who would be able to do that. Were there any further questions you had? Any further questions you had? Counsel, I appreciate your taking the time here today. This is an incredibly important issue. Did we get the sign-in sheet? Okay, I'm seeing one sit here without any signatures. Oh, they're off to the side. Never mind. I have those. Before we leave, though, I did tell Mr. Lujan if there was anything he wanted to add, comments, that I give him that chance. Again, not sworn in under oath. I know he's an officer of the court. So, Mr. Lujan, is there anything that you wanted to add today?
No, this is a top priority of ours, and we've been listening very carefully. We'll make sure we follow up.
I appreciate it. It's a top priority for us. I would tell you, we have time standards to meet. We have to try and get these cases processed quickly. The legislature has made it very clear to us also that these are cases that we need to deal with because of the children involved, the parents involved. So I think it's just time that we all sat down and got our hands a little dirty, but got it done, is the only way I can say it. We have to get this done now. Thank you, folks.
Thank you so much for your time today.